dear audience, welcome to 2021 World Intellectual Property Forum, the online virtual conference. I'm the moderator, Professor Mei-Hsin Wang from National University of Science and Technology, Taiwan. I'm the Fellow Royal Society of Chemistry, UK. I'm here for the panel titled Controversy and Friend for Standard Essential Partnering Code. In this panel, we are very honored to have Sir Christopher Floyd, the former Lord Justice of Appeal, UK Court of Appeal, England Wales, Honorary Professor of Law from University College London, and Professor Randall Rader, the former Chief Judge of United States Court of Appeal for the Federal Circuit and the Rader Group. Professor George Thomas Voigt, the Presiding Judge of Germany Federal Patent Court, and Dr. Joo Sup KIM, the former Chief Presiding Administrative Judge, IPTAP, Korea Intellectual Property Offices, to share their views on the panel titled Controversy and Friend for Standard Essential Partnering Code. Our speaker is Dr. Joo Sup KIM, the former Chief Presiding Administrative Judge, IPTAP, Korea Intellectual Property Office. Dr. Kim, may you kindly enlighten us the SEP and FRAND issues in Korea?
Well, first of all, thank you for your introduction, Professor Mei-Hsin Wang. Good afternoon, ladies and gentlemen. It's my pleasure joining here on the topic of controversy and friend on SEP IP code. Usually, I do share my view on this from my industry experience. Well, under the COVID-19 pandemic, every audience and attendees in this panel discussion, be strong and stay healthy anyway. All right. So first of all, to your questions, whether FRAND licensing is hinder the licensing or not. Well, FRAND license itself-wise, it does require to have a FRAND terms in the license agreement between SEP holders and potential licensees. Well, in short, I believe this is very useful for innovating and promoting the technology, especially defined as standard technology in the telecommunication area. So it would be very useful in that regard if we overcome some controversies that we are talking today. So under the current situation, this is more crucial than ever, considering the expanding business in the coming fourth industrial revolution. Well, such technology, AI, IoT, and perhaps AR and so on, those are important things. So to establish a FRAND license, it's necessary to analyze the licensing agreement, whether SEP owner has agreed with FRAND terms with other licensees. So in view of FRAND, licensing terms must be a kind of FRAND terms and be transparent in view of FRAND licensing. So in that regard, FRAND terms is the most important part. What is FRAND terms? That's important key issues. Let's say most likely FRAND terms is very thorny issues because it will become a different animal in view of licensor and licensee side. Of course, there are several other factors to be considered when we define FRAND licensing, such as negotiation in good faith, whether there were any FRAND offer and timely FRAND counter offer, and how about acceptance. That's whether that's well-based, licensing guidelines anyway. So to see what's the FRAND rate is the key issues in judging the FRAND terms. To judge the FRAND terms, what would be the reasonable or the fair friend rate as one of key issues. In most recent cases from the court, judges really handles the definition of friend rate. And they approach it in several ways, such as top-down calculation and bottom-up approach, or establish comparable license. That is, most important part. So, how we can maintain friend rate in friend licensing? That's key issues. But in my experience, the standard friend rate must be provided by potential licensors anyway. Especially, there are two types. If it goes to SP holding company, such as manufacturing company, so manufacturing company versus manufacturing company, it would be very reasonable because both company knows what's the definition of friend rate and the secret of standard of essential definition, patterns. And also other things too, business environment, very similar. So they can balance either party's patent portfolio, and normally they take into cross-license agreement. I don't think it's not, so unfair in view of, SEP manufacturing company-wise. But when it goes to SEP holders, such as NPE versus manufacturing company, that is much more problematic. Why? Because NPE does not have any backfire at all when they come to manufacturing companies. So in that regard, what would be a really reasonable and fair friend rate? Which means that friend rate wise, always it must be provided by the licensor anyway. So if there is a friend license of a friend rate, I think to a certain degree, MP must declare what is the friend rate. Why? Because they have no backfire at all. And also be fair to all potential licensees in the industry. So they set up a standard friend rate, then it must go lower, considering all other factors. That is most important things. Of course, there's no way the licensee keep a one license agreement that applicable to all licensees having the same royalty rate. It's not possible. It must be varied a little bit. That is the current situation. That's why people are complaining a lot. But in short, I believe in the case of MPE, they must declare their friend rate to a certain degree to the relevant industry. That's important things. That's my understanding. And it goes on the further about world global license. In several courts, they granted global world license. Well, that's much more severe to a certain company, such as small and medium companies, national, country-wise, which means that the company is not enough to cover the whole world. Why they have to take a worldwide global license? How come they have a single country basis license instead of world global license? I think that must be considered very serious. Why? Because friend dispute wise, this issue is independently separate jurisdiction from country versus country. That's why, in that sense, I strongly, suggest that kind of licensing type must be acceptable as well. And other things is, SSPPU, the smallest sellable patent protecting unit. that is critical issue to calculate the damage issues. Well, this concept has become very popular since it was born and introduced, one of my good friends, Judge Rader, in Cornell versus Hewlett-Packard cases. And it's been said that this issue has been determined by judges, not by damage expert, even if, damage expert may say different way. But as you know, SEPs patent, which claim covers an aspect of technical background, whether it's Apple, whether it's, computers, mobile, the party implement the standard into commercial product. When court judges decide of infringement of the product, there must be either reviewed and identified by a product basis. But what is the product basis? That is important too. Well, the product means that the product must be covered by the scope of claims in the patent. It doesn't go beyond the product, what the reach of its asserted claims. That's too broad. Well, of course that, the patent holder can say that, well, it said that make, use, or sell, which means that if, one small component that included whole part of invention, still that component can be integrated into our end product, set product. In that case, they say that, well, the set product as a whole is the royalty-based product. But in return, if it goes beyond that, the whole world become their royalty-based product. Absolutely, that's not true. So that what I'm saying is SSPPU is very important concept. It's not only limited to such as component. It is whole spirit of infringing theory in the court, which means that that is the royalty-based product and it must be decided by the judge. Of course, sometimes jurors in the United States may decide different way, but still it must be corrected. It happens in the juror's verdict by the judges. Judge must decide the infringing product. And then that infringing product is the base of royalty base, royalty rate base. I think that's important. Whether regardless of EMBR, what people say that entire market value versus SSPPU, in my view, that's not parallel sizing concept. It's one concept, but when damage expert interpret the damage amount, they approach in a slightly different way. But in my sense, in my view, it must be decided, court judges, it's well defined by the law already, so that, in the future, regardless of SSPPU and EMVR whatsoever, doesn't matter. What is the infringement decision and what is the accountable, corresponding product, infringed product? That is all in my view.
Thank you very much. Yeah.
Go ahead. That's first question. Anyway.
Yes, first question. Okay. So thank you very much for your very detailed and comprehensive experience sharing based on your work experience in the court and also in the industry. But there's another controversy about the information. The SEP owners, they claim their compliance with the FRAND guideline. They always say so, but it would be a true novelty if they sincerely disclose every piece of necessary information to all the clients, as we can review the cases such as TCO or versus Ericsson's, there are always arguments. But however, as you mentioned, in the business world, the price should be reflect to the quantity. That's reasonable. Nevertheless, there are more factors, skills to influence the price, such as the negotiation skill, market power, policy, connection between companies as well. So the licensor always insists they already compare with the friend, but however, the lack of information equivalency, the licensee always feel otherwise, and they have to see the justice or remedies from the call for the trainee faction, and the call have been due diligence to calculate all the royalty rate based on all the statistic data, or even depend on AI to identify what is the SEP, what is not SEP. But may Your Honor kind of share the view, because currently how to confirm the SEP pattern is still kind of issue, though there are a lot of independent expert, co-experts, standard organization, etc. But based on your opinions, how can we accurately confirm the SEP? And then if it's only when we can accurately confirm the SEP distribution, then we can accurately calculate the royalty, right? So we really depends on your experience sharing for the current controversies.
Okay, well, regarding information disclosure about friend rates, well, that is one of the key issues in the intellectual property licensing matters, which means that parties do agree to enter an NDA agreement when they are involved in licensing negotiation. Well, that is important thing, that confidentiality agreement, what's been called otherwise. But this is a common business practice used to protect commercial interest of a licensor or a licensee, because they have to keep a certain degree of confidentiality when they are involved in licensing negotiation. Well, that's very common. But if that happens, then the licensee cannot disclose their licensing, terms, especially friend terms, to others. And also, they don't have the opportunity to get some other existing licensees' friend terms at all, which means that they don't know whether they have a friend terms or a friend rate at all. No way that they can find it unless they will compare their friend terms with the other licensee terms. That's pretty unfair. I do agree with that. But in that sense, I normally request for the potential licensors saying that, well, for the confidentiality, absolutely keep in secret. But the most important part is that the other licensees' friend terms must be disclosed so that we can choose which term is relevant to us and appropriate to us. Other than friend rate, rate itself is very important things. And also, I believe that's very fair request to the potential licensors. I cannot disclose whether I received all that information already in my previous licensing negotiation or not, but to a certain degree, I did have enough information anyway. So that in that regard, my point is that if there is a potential licensor and potential licensees, considering the licensing negotiation, the potential licensee must have enough information about their choices in getting the fair and proper friend rate. That is most important part anyway. Even if, they don't disclose it, once two parties go into the court, indirectly, that kind of information must be disclosed anyway. So to show friend terms must be disclosed to imminent potential licensee during the negotiation if they signed NDA. That's important thing. I think that's fair request, and it must be accepted by the potential licensors as well.
Thank
I
you
don't
very
know whether
much.
that's enough to your questions or not.
Yes.
But
We will further would
okay.
like to inquire your expertise, because you have decades working with LG before you join IPTAP, Korean Intellectual Property. And actually, you are a legend in this work, so in IP world. So would you mind just give us, enlighten us, how you confirm when the SEP holders, they come to you and they claim their conditions, their royalty rates, their profile, how can you confirm the SEP patents? Because a lot of time they bluffing a lot. There's always more than they claim. So how you deal with these negotiations?
Well, that's very good questions. Well, many licensees may have a question whether they are paying the royalties under qualified standard essential patent or not, which means that they may are paying a lot on false standard essential patent, or perhaps invalid standard essential patent. That is, if that happens, it's crazy. They are paying a lot more than any other body.
Yes.
And usually the standard setting bodies such as ETSI, ARIB, and CCSA, they are not liable about verifying standard essential patent at all. But here's one big issue: is the headache is that over declaration as a standard patent before standard setting bodies, because they are not verifying at all. They just receive it once the formality is met. So that if this problem will go to the practical area, such as SEP holding company versus SEP holding company, well, I don't think that's so problematic at all. But still, if it goes to MPE, SP holding MPE versus SCP company is headache, because SCP holding MPE do not have defenses at all. They just hold the papers and asking for money. That is problematic. But most case-wise, SCP holding company, does have some internal resources to verify standards essential patent. But if it goes to small and medium companies, they don't have enough resources to verify standard essential patent internally. So if it goes to big company wise, I think they will resolve through technology meeting between two normally. But if it goes to MP versus manufacturing company, that's problematic. In that case, well, normally in a pool licensing wise, what's been suggested were that pool licensing entity designate several neutral qualified companies and law firms, and they can review it and report it to the pool licensing entity, whether those are verified standard essential patent or not. That's a normal way of pool licensing entity is accommodating. So that's one way. The other way is that, well, even if that's not suggested, if potential licensor and potential licensee, if they agree, they do need to have a third-party report saying that this is standard essential potent or not. Simply, potential licensees cannot rely on potential licensees' argument. These are standard essential patent because these are declared standard essential patent before the standard setting bodies. Actually that's not enough. So that I think we thus need to have a neutral, qualified party, such as law firms or such firms. We do need third-party report between two. I think that's a fair request as well. And then the potential licensee can review the report and may argue further and decide later. I hope nowadays is AI year, so that I hope AI system may help this problem soon anyway. That's my personal hope, but if not, is third parties report is the most important part, and that's one solution for that.
Thank you very much for your honest, in-depth, and comprehensive explanation. It helped us clarify a lot of controversies of SEP and FRAND. Thank you, Dr. Kim, for your very kind sharing. Before we close in the panel, we're wondering, is there any comments you would like to suggest or address to further teaching us a little bit?
Yes. Things in addition to the previous comments, to resolve all of these headaches, we need to have certain tools and vehicles. What is that? As people say, and also courts say slightly different interpretation of FRAND terms and FRAND licensing, and that is very natural. Considering that, I strongly suggest that each country must have a standard licensing guideline for SEP based on country basis. So at the minimum, a standard licensing guideline must be announced so that everybody understands what's the licensing environment in a certain country. I think that's important things. Thank you.
Thank you, sir, for your very kind suggestions. Before we close the panel, on behalf of the conference organizer and the audience, we would like to address our sincere appreciation for your honest, very kind sharing and very meaningful, very knowledgeable teaching. We hope in the near future, we will have the opportunity to invite you back again for a more enjoyable panel discussion. Thank you all.